जाएगा तो उसको curtail करने के लिए कोई ना कोई एक particular provision होगा. So there is a provision also to curtail this particular framework of right. So there are restrictions mentioned in Article 19, Clause 2, which is very, very important to understand. When the Constitution was made, there was this term mentioned as restrictions. By first constitutional amendment, the term reasonable was inserted to this part, so it became reasonable restrictions. What are the reasonable restrictions on the freedom of speech and expressions? They are security of the state, relations with foreign state, public order, morality, decency, contempt of court, incitement of an offense, sovereignty, and integrity of nation. So these are the restrictions, form of restrictions which are attached to this particular right of freedom of speech and expression in Indian Constitution. But it is not just the Indian Constitution which talks about a freedom of speech and expression. This particular part this particular right crosses the boundary. The UDHR, United Nations Declaration of Human Rights, in its Article 19 mentions about the same. Everyone has a right to freedom of opinion and expression. Yes, and Article 19 of ICCPR, International Covenant on Civil and Political Right for that matter. Everyone has a right to hold opinion without interference. So when we look into this framework, wherein the Indian Constitution in its Article 19, Clause 1, Subclause A mentions about the same. Universal Declaration of Human Rights under Article 19 mentions about the same. Article 19 of International Covenant on Civil and Political Right mentions about the same. So when we look into this framework, there has to be some way which is to be given to this particular right to express yourself. Yes, and to the right of speech. Yes, and how it's relevant to all of us, because this allows us to seek, receive, and impart information, ideas. Yes, either in written form or in verbal form, or so written form includes the print form as well. Now, when we look into this part, wherein I've already told you that the first constitutional amendment was the reason behind adding of this term reasonable to Article 19, Clause 2. So while we look into the freedom of speech and expression as an individual right, we have to look into certain other factors as well. What used to happen is earlier in the traditional framework, wherein there's a speaker and there is an audience. Yes. Right now also there's a speaker and an audience. Yes. But the entire stature of how this information is shared has completely changed. Let us look into this particular session which we are a part of. What is the intermediary? But on which platform are we sharing our opinion, or are we sharing our expression, or where we are sharing these ideas? It is the Zoom platform. So here in Zoom is an intermediary. Zoom kya hai? Ek intermediary hai. Yes. What happens is government sometimes controls the free speech in a direct manner or an indirect manner. Yes. In a direct manner, they come up with certain kind of law that if you say this part, or if this part of your speech or expression can invite certain kind of punitive actions. Where an indirect control is such as what happened during the time of emergencies, that there was restrictions made on the amount of paper which a newspaper agency can really use. That was an indirect way of doing so. In these times, the indirect way can be restricting the use of internet for that matter. The internet has become the source of sharing of all information in this present world. But what happens if a government stops this particular right to access the internet, wherein this particularly will affect the individual right to share or impart information or to receive information. So that is what I'm saying. The entire framework has changed in modern times. So while you will be, 7 of you will be participating in Oxford Prize Media Motor competition, what will come to you very, very handy is the relevance of intermediary to this part of freedom of speech and expression and chilling effect. Now, let me take you forward to this. There was a case on Shreya Singhal versus Union of India. We all know that Section 66A of IT Act was struck down, and in that particular case, it was mentioned that the doctrine of chilling effect on a speech considers the probability of legal provisions causing psychological barrier in the free exercise of right. Let me give you an example which which I had a discussion with someone, and they pointed it out, is that when we go to a school, let's take an example. There was one teacher who used to come and give punishment to one individual. Looking at that particular individual getting punished, we all realize that ये हमारे साथ भी हो सकता है. This can happen to all of us, and so that ensured that we do not do certain things. Yes, so that made us stop from doing something. Yes. Now take this example. If that's now this replace this teacher with a state, yes, they come up with certain action against an individual, so that all other individuals take this as an example and do not do a particular thing. Yes, and if it is relates to restricting your speech and restricting your expression, it will be called as chilling effect, as easier as gets it. Yes. Now the chilling effect is a suppression of free speech and legitimate form of dissent. Yes, among a population because of fear of repercussion. Take an example. There's a journalist who has written something against the government or a particular company or etc etc, and you realize that 2 days after, certain actions are taken against this journalist. Now this goes as a example, this goes as a lesson to every other person who is working in that profession, that you shouldn't do this. Yes, now that will impact the freedom of press, that will impact the freedom of journalists, that will impact the freedom of expression. Yes, so this is how it is done. Yes, there are other forms of doing the same. From the legal point of view, I have already mentioned to you that this the term chilling effect has a negative connotation altogether, and any state action which can come to our mind that this can happen, so we should not be doing so. You curtail your right of speech and expression. So that is what is easy explanation of chilling effect. Now, what are the three main techniques that are used by state agencies to ensure that the individuals, that the citizens' right to free speech and expression is curtailed, or there is chilling effect attached to that particular right? The adoption of deliberately ambiguous legal provision. Now, what are these ambiguous legal provision? Like coming up in a IT Act, intermediary liability rules, they come up with a particular term called blasphemy as one of the factors that should be considered while removing of a content from intermediary. But that particular term is not mentioned, which you have widely seen in Article 19, Clause 2. The reasonable restriction part doesn't mention that particular term, blasphemy, but it is mentioned under a particular different set of laws. So this is where it is not connecting. So there is an ambiguous legal provision for the matter. The arbitrary enforcement of these provisions against the most vocal critic. Again, I gave you that example, that if there is a particular journalist, or there is a political party person, or there is another individual or a particular company which has come out with certain information which the government believes that it will affect its how it's perceived, and a certain action is taken by the government, it causes a chilling effect because it sets an example that you should not be doing so. The adoption of disproportionate sanctions. For that example, if somebody has to be just given a caution or has to be made a party to a civil action, you initiate a criminal proceedings against those individuals. Yes, such as happens in the case of defamation. Yes, so there are three main techniques to ensure that people's right to speech is restricted in some sense or the other. Now, there are times when the fear is being created among individuals. Let's take an example of what happens when WikiLeaks, Julian Assange came up with official secrets and they were leaked. Yes, his PayPal account was freezed, so setting an example for other individuals. Yes, and again, what happens is it creates a real dangers for all of us. There's another concept of a strategic lawsuit against public participation. If some individuals come up with a PIL, or some individual is too much interested in what government is doing, yes, or a particular private company is doing, this private company for that matter will come up with will give this individual a slap. The slap here doesn't mean that coming and beating this individual, but a strategic lawsuit against public participation. Now, what happens when this thing happens? A big company comes and files a case against an individual, and we all know how these litigation comes to the citizen of this country. It takes a lot of time. There's a money involvement. There's a time. There's already a time involvement, and then there is all kind of extra pressure. Yes. So to avoid all these things from happening, people now take back their active participation, their public participation, and these big companies or these government organization win. Yes. So the slap is also one of the ways of creating fear amongst individuals. Yes. Now, let me take you through another part which I was mentioning about the intermediary liability rules. So in we have an information technology act. हमारे देश में एक information technology act है जिसमें एक safe harbor principle है. Safe harbor principle states that there are various intermediaries such as Twitter, Facebook, हो गया Instagram, etc., where people come share their opinions. So that's a platform where the opinions are shared. Yes, that's called as intermediary. What happens is safe harbor principle allows them that if some information has been shared on their platform without their knowledge, yes, and that affects some individuals, then these companies will not be held responsible. Yes, if they are not aware of this particular information being shared. Post which there came intermediary liability rules. Yes, intermediary guidelines rules, which are related to safe harbor principle. Now section 3 clause 2 of these rules obliges intermediary to make rules and formulate certain condition that if somebody displays, uploads, modify, publishes, transmit any information that is in contravention of this section, there will be some punitive actions with respect to making of this information. Yes, and what are the different terms which are used within this particular framework are grossly harmful, undefined, blasphemous, harassing, hateful. It's like an open interpretation can be done to these terms. Yes, so this is creating an ambiguity, an open interpretation. So anybody who says something or the other can be brought together with all these pointers. And what happens is there's another section. This section clause 4 provides that this intermediary, when somebody approaches them, had to take an action within 36 hours. When the state approaches them, it has to take an action within 36 hours. Now what happens is, due to this, that these big companies fear that certain action will be taken against them, and they fear their public opinion will be set up against these individuals. So what happens is these companies take an action urgently. Yes, without on looking into what was the reasoning behind this. Did this really affect some other, this really fall within all these terms which were mentioned under rules 3 clause 2, or they just do it? Yes. So what has been seen, they really just do it for the sake of saving themselves from the government actions. Yes. Now what happens is, if we look into a particular case law, which there were a lot many case laws related to Subramaniam Swamy, and these are most of them are in relation to the defamation point of view. If a person is under fear being sued, he may not express himself freely on public issues, and this would chill the public debate, held in the case of Ram Jethmalani versus Subramaniam Swamy. And this is really, really true. If you want to say something, but then somebody tells you that if you speak this part, or if you say this part, if it is heard by other individuals, there can be a case against you. For that matter, if you say something and after 15 or 20 minutes there's a police personnel who comes to you and to arrest. Yes, for other people it will be set an example, and it will create a fear that we should not be saying something. Yes. So that was mentioned, that should not be done because it affects the public debate on issues. Same in MK Sharma versus Sangeeta Gupta, there was something, it was with respect to Vishaka guidelines. So a statement made to the investigating committee, we all know that there's an investigating committee which is set up when there's a sexual harassment charge made within an organization, and it was held that a statement made to this committee under Vishaka guidelines cannot be subject to a defamation suit. If at the later stage it comes on, this was not true. This cannot be subject to a defamation suit, because then it will really, really affect that part, that it will cause the aggrieved person not to say something, because that can later on can lead to a defamation suit. Yes. So therein again, the term this chilling effect was mentioned by the court, MK Sharma versus Sangeeta Singh. Now, law should be construed in a manner so as to avoid chilling effect over freedom of speech and expression, held way back in R. Rajagopal versus State of Tamil Nadu and S. Khushbu versus Kannimal. But what I really pointed out to you is that in the intermediary liability rules, certain unclear terms are being mentioned. Yes, and that is where the ambiguity comes into the picture. But before we realize is that do we have this doctrine really recognized in our country? There are other countries where it is recognized. That to our neighbor Sri Lanka recognizes that in a case of Channa Perez versus Attorney General, it was recognized that that if certain activities are stopped, there certain actions are taken against an individual who participated in some form of activities, then that would cause a chilling effect, and that will affect people coming together. Again, Canada also recognizes this particular doctrine of your FIDA versus in McIntyre case, it was realized. But again, what is really important to all of us is that this concept ensures that the individual who want to make some speech, who want to say something, but they fear the state action, they do not speak out that thing in a way and large. That is where this concept of chilling effects comes into the picture. Now, now coming to this part wherein this all originated, the concept of chilling effect originated in the United States of America. Later on, several case laws were on this particular point were taken by the European Court of Human Rights. In other jurisdiction, it is equally recognized, the concept of chilling effect. In India, it is still a developing law for that matter. What is really I want to make sure that you are aware of is that this particular concept originated in a Supreme Court case, Lamont versus Postmaster General. And when Justice Brennan mentioned about this particular part, that how does this they use the term deterrent effect rather than chilling effect. So there's a deterrent effect on freedom of speech and expression. Later on, it was used in several of the case laws in our country as well. But what really should interest all of us is that there are Indian case laws. There are Indian case laws for the matter, and there are Indian laws. In Indian laws, if we look into this part, wherein we talk about either the defamation part or the sedition part, we figure out that these laws, which were framed in many years back, do they have a relevance at this point of time? And if they at all have a relevance, does certain provision of these laws causes chilling effect? Now, for that matter, if these laws have been used, there has been a use and misuse of these laws for that matter. So certain times what happens is the individual fear on speaking something against the government, or speaking against a particular big organization for that matter, because they fear certain actions will come to them. And that is where the freedom of speech and expression is restricted. You want to say something, but you will not say something due to the fear of certain actions being taken against you. So what is really important is that all the laws which are created, they specifically come up with this framework where all the terms are very finitely defined. Yes, there's no ambiguous nature of words which is used, so that it cannot be construed in any other sense. Yes, so if a term is particularly defined, security of the country, it should be defined. What do you really mean by security of the country? Yes, because otherwise what happens is there's an individual who is then stopped from speaking something, because what not this particular whatever you say can be included in a certain portion of this part. Yes, you want to say something, but later on you do not know that that can come under the Article 19 clause 2, causing incitement. Yes, so it is really important that the laws are very clearly defined. Yes, so this is where the chilling effect relates with freedom of speech and expression, which is relates with Article 19, Clause 1, Subclause A of Indian Constitution, or even Article 19 of UDHR or ICCPR. Yes. Now the platform is open to questions. If you have some questions, please let me know.
If we can have any questions, you can directly reach out to us, or you can post it in the chat box. Okay, so we have two questions which are there. So first thing is, do you believe that freedom of speech and expression is essential for survival?
Okay, Ishan, I know that looks like a question asked by somebody who is in class 11th and 12th, but it's really, really important, because what happens is if you look into the Constitutional Assembly debates, or you look into if you go to YouTube and watch Samvidhan, and you look into the debates which were ongoing with respect to the freedom of speech and expression, you ideally identify that how important it is to have this kind of a right where you are able to express yourself, you are able to share your opinion, where you have a right to receive an information. That becomes really, really important. For that matter, if you want to say something, yes, but you are not allowed to say that. Yes, that's a different feeling altogether, that you cannot share your opinion, or you cannot express yourself, or you want to say something to other individual, but you cannot say so. So freedom of speech and expression give you that kind of right. And we know that in while the freedom struggle came, while we were in the freedom struggle, this right was one of the foremost important part. We understand that there were certain draconian laws created by the Britishers, for that matter, putting restrictions on the printing of the newspaper, for that matter. But later on, if we look into overall aspect, if there would not have been the freedom to express, the freedom to have an opinion, the freedom to share our opinion, then all the rights will fall short of this, because this is a real one. Freedom of press is ideally a part of right to freedom of speech and expression. So if there would have been no press, the fourth pillar of a pillar for this particular democracy, then democracy will come into shamble. Whatever the governments would like to do, or whatever the big organization would like to do, that will eventually happen, and that would go into back times when there was no ideal law. So this is a really, really important loss, and therefore it is recognized not in India as a right, but globally as a right. You look into any constitution of this world, which, if a country is democratic in nature, or has a constitution, this right will be there. I have got a question, sir. What do you think India's future looks like with respect to the freedom of speech and expression? Do you think it will become something that is more restricted? See, Yosha, this is an again really, really a relevant point. And what I look into this law is that with coming as an internet era, the digital domain is coming. So there will be chances for individual to share their opinion, express themselves far more better than was without the internet or the digital era. So I can say that with respect to the freedom of speech and expression, the right will see a exponential growth. Yes, people were expressing themselves to an individual in a physical form. Now they started expressing themselves to in the world of internet. Now they are going to express themselves in the world of metaverse. Yes, and whatnot. Sometimes these people would like to express themselves while taking a space travel, and somebody will come up with the rights for them as well. So this right will continue to grow. Now, do I think that it will become something that is more restrictive? Completely depends upon what kind of government is there in a particular country. Completely depends upon how educated the individuals of those countries are. When we look into our country, India, then I don't think that there will be more restrictions, because we have Supreme Court in India. We have certain pressure groups, for that matter. If you read the political science, they come to this part, and where they share the opinion of the people. They go and approach the code of law, and that is where I believe that the restrictions, although will be imposed from time to time by different governments, so as to ensure that a negative opinion is not formed against them, but still the Indians, the citizen of this country, will come out winner, and and the Constitution provides for that. The Constitution provides for the right to constitutional remedies. The Constitution provides for its citizen the freedom of speech and expression. Ishita is asking, defining some laws precisely may end up severely limiting them. What are your thoughts on this? Ishita, what I particularly believe is, if you define some laws precisely in the more point, certain provision of law which can later on entail or can relate to something called as causing a punitive actions. Yes, what I mean to say, if certain provision of law which can cause punitive action, which can lead to punitive action against an individual, they should be clearly defined. Yes, because once they are defined, an individual, the citizen of this country, will know what not to do rather than what to do, because what to do has already been defined. What not to do is always coming into this framework where it's defined in different case laws, and it's constituted in different senses by the government as they want to use it. Yes, so therefore I believe that when the provision of law calls upon foreign punitive action, they should be precisely defined. uh, Bijoy asked this, is it true that the freedom of speech improved a lot with the arrival of social
Social
media?
media.
Bijoy, this is an amazing question, and yes, it has done so. Now these days people share anything to anything to everything on social media. So now that has come as an important aspect for the people, that they have got a platform. It has come as a platform where people can earn a lot of money by speech and expression. It has come to our knowledge that people are now sharing anything from everything, and therefore more and more laws, clearly defined laws for this digital era, should ideally be placed. Yes, so what is the need of the hour is to understand how the society is growing. Understand, laws are made for the society. Yes, as the society is growing, the law should also grow. It should not be stagnant, as what was created should ideally be true for another 500 or 400 years. The IPC which was made, certain changes can be made to it, because the society is growing, the individuals are growing, the knowledge is growing, the education is the society is getting educated. So for that matter, yes, the when I look into the freedom of speech, it has improved a lot due to arrival of social media, and that is a good thing. Yes,
I have
Bhave,
received a direct question, sir, in
yeah.
which it says that, so this is what we all have faced, and the golden triangle, which he says, 14, 19, and 21. And how a student, if I'm going to just start my constitution law classes, how is it I am going to relate, and how it is going to be easy or difficult to take this particular thing, and how am I going to solve this particular triangle in the upcoming semester exams?
Okay. Regarding these semester exams, all the very best for them. Uh, let's really look into article. Then you need to what the basic frameworks comes into the picture is what is the correlation between these articles 14, 19, 21. Yes, they fall in the part 3 of the Indian Constitution. There are certain case laws which connect this framework. If you look into Article 14 framework, you first you there's two era where it is defined pre-EP ROEPA, post-EP ROEPA. So once you will be having those classes, you will understand this basic framework, what happened post EP ROEPA, and how that particular thing impacted Article 14, and how that particular right to equality was correlated to freedom of speech and expression. And all of this combined together with Article 21, which is just one line for right to life and personal dignity, right to life and personal liberty. Yes. Now looking into this has gone and extended by far. Yes, these rights have extended by far. So the golden triangle will be formed. There will be certain case laws, and ideally you will be able to ace that exam, but you have to define 14, 19, 21 certain case laws where these three are taken together, and that's it. uh, what's
Bhavesh is asking a question
regarding.
regarding to the media. How can we draw a line where freedom of speech is exercised, but the right to privacy is not endangered? Because in case of media, it is a very, very thin line.
Okay. Yeah. So this is again a very amazing questions, how to draw a line regarding to the media, how we can draw a line where freedom of speech and exercise but the right to privacy. Of course, we have seen this paparazzi running in and around the influencers, running in and around the actors
Okay.
for that matter. We have seen that a lot of media agencies follows the politicians by and large. There has to be a line drawn, and who will draw this line are these individuals. Yes, every time you need to every time you have to form a particular thing called SOP, standard operating procedure. And time has come when these media agencies should come up with this, how far they can go into this part. And there and these again I'm saying that digital, it is not primarily the traditional media which is going closer to this dividing line, but it is the digital media which is going closer to this dividing line. So more laws should come to this framework, that how far you can go breach somebody's privacy. But again, privacy is a part of Article 21 already. A lot many case laws are mentioned, but they are only available if your privacy is breached by the state agencies. Therefore, it's the need that some certain kind of a standard operating procedure should be made by these digital media agencies, and the social group should come forward in ensuring that these are being made.
We have another question, sir. Under which circumstances can government interfere with freedom of speech?
Okay, what are the circumstances under which the government can interfere with the freedom of speech? My dear friend, if you look into Article 19, Clause 2, if you look into Article 19, Clause 2 very clearly, you will understand that it is in this part when the government can interfere with the freedom of speech, as mentioned under the Indian Constitution, that if your speech affects the security of the state, uh, you share certain important information, you come online and you tell the world where a certain important codes kept your relationship with foreign states, you come up and make a statement that that this particular country is going to attack our country, and that's a false information for the matter. Public order for the matter, you come up with a particular information that there's a police agency coming and they will they everybody's home is to be destroyed in this particular lane. Now people come into this kind of a pressure, they start running. Morality is a very greater ground for that matter. What you can do, what you cannot, that for another session. Decency, contempt of court, we have seen time and again that uh, the court has taken suo motu cognizance, given a notice to an individual. Yes, incitement of an offense, sovereignty and integrity of the nation. So all these are the grounds on which the state can stop an individuals from making a speech. I see another question, which is by Dhananjay. Dhananjay, free speech can also lead to hate speech and situations where people are offended. So shouldn't there be some restriction? Of course, there are hate speech laws, Dhananjay. There are hate speech laws in every country for the matter, and you cannot make a hate speech. Yes, and therein again, it is very relevant that there is a line drawn. There's a line drawn when we are talking about this part of freedom of speech and expression and the part of hate speech. So yes, it is this has to be taken care of. Yes, deafening silence in ear of a hate speech was one of the article which was mentioned by the Indian Express. Um, wherein they mentioned about that how the cases of hate speech are growing up, and how India has grown from Mile sur mera tumhara to now the time and again when people are making certain kind of speeches which is which affects some one's others feelings, such as Haridwar hate assembly speech which was made in 2021, or there was some conference which was going on, and there was some statement made against a particular particular caste or particular community for the matter. So at times and again we have seen that there has to be a line drawn with respect to hate speech also. And Supreme Court, we all understand, agreed not so far on 11th January 2022 to take up with this particular matter via medium of PIL seeking probe into Delhi Haridwar hate speeches. So there are laws. Yes, Kapil Sibal highlighted FIR has been filed, no arrest being made, but there is a time when we must understand the difference between making a speech using your right to freedom of speech and expression or making a hate speech. Next question which I see is, does the doctrine of prior restraint harms freedom of speech? Yes, Anant. This does. This is what we were discussing, that if there is a prior restraint, it affects your right to make a free speech for that matter. That is what we were discussing, chilling effect, the ways of it is doing so, framing a law which is not very clear, or giving you that disproportionate punishment, or making an example out of you. That is where it curtails your free speech. Again, going back to that example which I've already given you. For an example, a teacher gives a punishment to an individual in a class. Yes, just and just to set up an example, what happens is the other individual remains silent. For the matter, if an individual, another form of doing so, let me go into the teaching learning space itself. So at times you ask a particular question in a class, or that particular question is not out of that particular topic, your mentor for the matter can, or your teacher can become really really not happy with that particular question, and that can also affect a certain time. If it affects within one individual in their marks which they receive an examination, it will act as a chilling effect for other individual to say something or to do certain kind of actions. Yes. So, or take an example at your home also. If you do something, your parents give you that punishment. It will ensure that you do not take that kind of action again. Yes. So that is where chilling effect comes into the question.
Why is that law not a subject in class 10 as mandatory, which can provide some important aspects of constitution like rights and duties? Absolutely.
Okay,
Absolutely.
Bijoy, I agree to this particular point. So in certain CBSE schools, uh, law as a subject has been introduced as an optional subjects. For that matter, there is I was from an ICSC school, ISC background, and there was something called history and civics. The portion of civics clearly mentions about basics of the constitution. I remember in my book in class 8th, there was the constitutional provisions were defined, rights were defined, and directive principle for defined. And if you are from CBSE school, again, the book which you go, the NCRT books which you see, if you open the first page and the second page is something about it is written preamble, I tell you very specifically, yes, either the preamble will be written, DPSP will be written, or fundamental right will be written. Nothing more than that. So even the very start of your NCRT book, any book you take out, a physics book, I tell you, yes, you will find that it starts with law, not with physics. Yes, that's how it has been taken into account. Ananda, should political speech be more rigorously protected than other forms of expression? No, for that matter. And that's, every speech has their own important. Political speech is a very, again, you have used a wide word for that. Political speech can now entail anything. Yes. So Ananda, you are trying to now ensure that if the answer is yes to your question, it can cause a chilling effect. Yes. So it cannot happen in that manner. Yes. Now, any other question, Ishan?
So just the last question is there we have. Do you believe that government at times is restricting people's freedom of speech and expression? Because there has been a lot of movie. Let's take example from movies where any movie which is formed against the government is held back, and but at the same time the peoples are more supportive towards it. For let's take an example for Article 15, the movie of what are your views on that?
Okay, see, these are indirect ways of indirect ways of affecting your freedom of speech and expression. Coming up with these kind of restrictions against the movie maker or the creator of creator of some something which is a part of their right to ensure that they can express themselves freely. But again, you see, we always see that sometimes what happens is some of the movies or some of these songs or some of these books do not get the clearance from the government agencies for the matter, and later on are very much loved and respected by an individuals. So that is where this real tussle comes between your freedoms, the government agencies, and what happens later on. Yes. So that is what is really important. And the good part is that we have constitution in our country. The good part is that we have this freedom. The good part is that the law on this framework is developing. So again, but what happens is such as we look into what surveillance was caused, for that matter, Pegasus, or what happens when WikiLeaks came up with a particular sharing of an information, that how the governments were dealing. Now once an individual tries to understand that there's something called surveillance, for the matter, you all use the internet when you are in your school, your college, or the places you are going to work. You understand that somebody who is the owner or somebody who holds the management of that place can see every activity of yours on what you're doing on internet. If that comes to the light that your network is being on a surveillance, what it will do, it will seriously affect your freedom of speech and expression. You will really think twice before searching for an information, before sharing of an information, or before receiving that information. Yes, what happens is when this entire episode came in US, that surveillance was happening on the people who wanted to know about something called terrorism. They wanted to read about terrorism. They wanted to understand how to save themselves from terrorism, but they were really frightened. They were really frightened that what will happen if the government is watching everything. Yes, so this is what happens when, and this is a kind of a chilling effect once you fear the state action which can entail. Yes. uh, Okay, so there is another question for the reason of being a lawyer. That the question is that how can the people have the knowledge of law? Yes, and the knowledge is with only the lawyers, and this is not true for that matter. What happens is the basics how a law is being created, or how it is to be ensured, or how it is said that the citizen should know about a particular law. It is published in an official gazette, and that is what is seen to be that it has been released for public knowledge. Yes, so the individuals for that matter need to know about the law of their land. Yes, and the law of the land for this country, and for the matter is the Constitution of India. That's primarily one law which you should know. There are other laws which you should be ideally have a little bit knowledge about, which affects your relationship with other individuals for that matter. Ishan, any other question?
No, sir. That's about it for right now. Currently, no more questions are there.
Okay, so now before I finish this session, let me take you through what was the entire discussion this evening, which we had. The discussion was with respect to freedom of speech and expression and the chilling effect, and the session is started with me defining what is chilling effect, what is freedom of speech and expression, uh, what are the news articles which were on this particular topic where the chilling effect was mentioned, whether it is with respect to Pegasus or it is with respect to defamation or sedition law, how the Supreme Court has dealt with this particular concept of chilling effect, or the article which I have written on the sedition, and where and how I have dealt with this part of chilling effect with respect to sedition as a law. And then where in the Indian Constitution the right to freedom of speech and expression is mentioned, what are the ground of restriction? A term reasonable restriction was inserted by first constitutional amendment, and Article 19 is only available to Indian citizen. It includes to receive, express, and have a secrecy of certain information. Then I also told you about this part wherein the UDHR, Universal Declaration of Human Rights, or ICCPR, in their Article 19 mentions about this particular important right to hold opinion without interference for that matter. Then we came to this part wherein the government can directly control free speech or can indirectly control free speech, and that is been seen time and again that the government these times do an indirect control on free speech. So one of the provision of the Information Technology Act 66A was struck down by the Supreme Court of India and Shreya Singhal versus Union of India, because that particular law was causing chilling effect, because people were fearing state action even before they were making certain kind of an expression. Yes, so chilling effect is suppression of free speech. Yes, because of fear of repercussion, it has a negative view. So this was the part which we dealt with. Other than that, we came up with the technique which is used by the government when how do they really cause the chilling effect. Deliberately ambiguous legal provision, arbitrary enforcement, disproportionate sanctions which are done by the government by creating fear amongst individuals, such as if you share some information, then your accounts can be freezed, or for the matter you can be sent behind bar. So or by big individual, big organization for the matter, or the government itself coming up with the strategic lawsuit against public participation, because people in this country and worldwide fear litigation, because time consuming money goes into this. So what happens is people fear this part, that a slap can come to them and they stop from taking certain actions. Then I told you about the intermediary liability rules, how there was uncertainty with respect to certain terms which were mentioned there but were not mentioned in the Article 19, Clause 2 of the Indian Constitution. Uh, the fear among individual which can come if an individual is sued for making a public debate. It was mentioned in Ram Jethmalani versus Subramaniam Swamy, a particular case on the statement made to the investigating committee on sexual harassment against workplace. Was mentioned under M.K. Sharma versus Sangeeta Gupta, how that can have a chilling effect for the matter. And laws on freedom of speech and expression has to be made in that manner that it should not have a chilling effect. Was mentioned in the R. Rajagopal versus State of Tamil Nadu and S. Khushbu versus Kandimal case law. Sri Lanka recognizes this part, Canada recognizes this part, USA was the country from where it all originated in the case of Lement versus Postmaster General, and other cases in the US mentioned about this part of chilling effect, whether it is Laird versus Tantum or Wieman versus Update Graph of 1952. All these case laws have mentioned about the concept of chilling effect. So overall, we see that this is a global concept, and chilling effect can really disturb, can really cause a curtailment to your freedom of speech and expression, which is a global right. So it's imperative that the laws are created in such a manner, or certain actions are not taken by government in such a manner that they cause chilling effect.
Thank you so much, sir, for summarizing what you have we covered in the last 40 minutes. And so this is for all the participants. First of all, thank you for attending the whole 3 days lecture. This is to inform you that if you have by any chance missed any of our parts, the recordings for all the 3 sessions will be sent to you on your email. And I'm so sorry. I was on mute. Yeah. So first of all, thank you so much for everyone to attending this session. And this is to inform you that if you have any doubts or something with us, and I'm just dropping her sir's email ID. Yeah. And the recordings of all the 3 sessions will be available on your emails, and you can definitely get in touch with us. And any doubts, anything, will be happy to help you.
Thank you so much, everyone, for joining in. And I've never said a no to a hot cup of ginger tea. So if you are in Bengaluru, in and around, or you wish to come to the city, you're always welcome to come to IFIM Law School, and let's meet and discuss more of these concepts. Thank you so much for joining in this evening. Please take care of yourself.
Thank you so much. Thank you, everyone. Take care.